Puncak Niaga is in the business of water treatment and operates 28 water treatment plants including Gombak Water Treatment Plant Gombak WTP. The raw water for the Gombak WTP is derived solely from the river Sungai Gombak, which is located at km 28 of the Kuala Lumpur-Karak Highway. The Gombak WTP is located 12 km downstream from the water intake location. Shabazz is in the business of distributing treated water. Shabazz has entered into a concession agreement dated 15 December 2004 with the Government of Malaysia and the State Government of Selangor, and is also a license under the Water Supply Enactment 1997, whereby Shabazz is empowered to provide or supply treatment water to the consumers in Selangor, Federal Territory of Kuala Lumpur and Putrajaya, which includes the areas in Gombak. Shabazz purchases treated water from the Gombak WTP to be supplied to the consumers in Gombak. On 9 September 2005, at about 2 p.m, a collision occurred between the first defendant's tanker, registration number BCY4383, and the second defendant's, registration number DAN4669. The collision occurred at km 29.2 of the Kuala Lumpur-Karak Expressway, with both the tankers heading toward Kuala Lumpur. Both the tankers at the material time were carrying crude palm oil. As a result of the collision, crude palm oil that was carried by both tankers had spilled onto the highway. The oil spillage at the highway had flowed into the highway drainage system and into Sungai Gombak, contaminating and polluting the river, including the Gombak intake. The contamination of the crude palm oil at the water catchment area was first spotted at about 2 p.m. by Puncak Niaga's employee, Mr. Abdul Aziz bin Ahmad, who later informed PW1 Mr. Ismail bin Hassan, the then regional manager for the central region. PW1 immediately instructed Abdul Aziz Ahmad to shut down its Gombak WTP at about 2:15 p.m. on the same day to prevent the contaminated water from entering the water treatment plant. As the amount of crude palm oil that had contaminated the water catchment area was substantial, no immediate action could be taken to stop the contamination at that time. In order to mobilize cleaning up operation, Puncak Niaga had to shut down its water treatment operation for 99.7 hours, 75 hours, which is equivalent to 4 days from 2 p.m. on 9 September 2005. Puncak Niaga thus claims against the defendants the sum of RM115,933.80 for expenses and losses they suffered due to the shutting down of the Gombak WTP for 4 days and the cost incurred in mobilizing manpower to clean up the crude palm oil from Sungai Gombak and the Gombak intake area as a result of the oil spillage caused by the collision between the defendants' tankers. As Puncak Niaga had ceased its water treatment plant operation for 4 days for cleaning up purposes, it was unable to supply and sell treated water to the consumers in the affected areas. Thus, Shabazz claims against the defendants the sum of RM190,442.84 being the cost for installing bypass pipes, hiring water tankers to transport clean water to the affected areas, and the loss of revenue or profit due to its inability to sell treated water to the consumers for 4 days due to the shutting down of the Gombak WTP. At last, as a result of the collision on 9 September 2005, the driver of the first defendant's tanker, Mr. Muhammad Rosli bin Abdul Rahim, was charged for inconsiderate driving under Section 43 Clause 1 of the Road Transport Act 1987, Act 333. He pleaded guilty to the charge and was fined RM4,500 by the magistrate.
There is 5 issues that we can extract from this case. First, whether the spillage of the crude palm oil caused the contamination of Sungai Gombak and the Gombak intake. And the second one, who was liable for the collision that caused the spillage of the crude palm. And the third one, whether it was reasonably foreseeable or whether the defendants could reasonably foresee that the oil spillage onto the highway due to the collision would result in the contamination of the Gombak intake. And the fourth one, whether Puncak Niaga was negligent in not taking any measures to prevent contamination of Sungai Gombak and the Gombak intake by putting warning notices or signage to inform the public of the presence of water catchment area Sungai Gombak at the kilometer 28 of the highway. And last, what was the quantum of damages suffered by the plaintiff?
So today I'm going to talk about the contentions made by the plaintiff side. So the plaintiff were represented by Ms. Chanti Supramaniam, assisted by Mr. Adrian C. Juhong along with Ms. Nurain Kamaruzaman. They claimed special damages from the defendants for expenses and losses suffered as a result of contamination of Sungai Gombak. So among the submissions made by them are, firstly, based on the damage of the first defendant's tanker, the first defendant's driver was irresponsible in crashing onto the back of the second defendant's tanker, causing the crude palm oil to spill onto the roadway and causing contamination towards the Sungai Gombak and the Gombak intake. So second, the defendant, who at the time of the accident were carrying crude palm oil, owed a duty of care as a road users in that they were aware that it would be dangerous if crude palm oil escapes or leak onto the highway. And then the third one, the collision site located at the kilometer 29.2 was designated or was gazetted as a water catchment area. As such, the defendants are legally required to provide a duty of care to the plaintiff who depend on the water catchment for their business operations. And then fourth, the defendants were obligated to exercise reasonable care by virtue of the statutory duty, as they could have reasonably been expected to anticipate that their carelessness would result in the plaintiff suffering losses and incurring costs in the event that crude palm contaminated the water catchment area that is needed for their business. As for the last one, given that the area was gazetted, the public is presumed to have been aware of the presence of the water catchment area. As a result, it is foreseeable that the plaintiff would incur losses in the event that the defendant's negligence causes the area to become contaminated with crude palm oil.
On contentions by defendant, the first defendant was represented by Mr. Vignesh Silvanathan along with Mr. Saifuddin Shahruddin. Among the submissions made by them are, the first one, the conditions present at the scene of the time of the incident caused it to happen. First, the driver of the second defendant abruptly halted. The second issue is the state of the road where construction has only allowed for the opening of one of the 3 lanes. The second contention is Puncak Niaga was not putting up any signs to alert travelers to the presence of a water catchment area on the roadway, because he was unable to predict that the oil spill would cause the water catchment to become contaminated. The first defendant owed the plaintiffs no duty of care. The third one is Puncak Niaga neglected to put in place any safety measures to stop the pollution caused by the Sungai Gombak oil spill. In 2002, a vehicle accident in Sungai Gombak resulted in a comparable pollution accident. Puncak Niaga need to have been informed and taken preventive action as a result to ensure that the same occurrence did not occur again. And the last contention is the first defendant only owes a duty of care towards other road users, but not to the plaintiffs.
Moving on to the court's judgment, in the first issue, in paragraph 21, it stated that it is very probable that the contamination at the water catchment area of Sungai Gombak and the Gombak intake was caused by this oil spillage from the defendant's tankers as a result of the collision. For the second issue, in paragraph 28, it is stated that based on the evidence of PW4 and the facts of the case, the court viewed that the first defendant is solely negligent, liable for causing the collision with the second defendant's tankers, at km 29.2 of the Kuala Lumpur-Karak Highway. For the third issue, it is stated in paragraph 54, the court finds that the first defendant owed a duty of care towards the plaintiffs and that they have breached their duty of care. The court also viewed that the first defendant could reasonably foresee that their negligent act in causing the collision will result in the oil spillage contaminating and polluting the Gombak River and the Gombak intake located nearby, causing losses and damages to the plaintiffs who are relying on Sungai Gombak as their means of business. The fourth issue is stated in paragraph 58 that the court viewed that the principles of contributory negligence is not applicable to the first plaintiff, as it was the first defendant's negligent conduct in causing the collision and the spillage of crude palm oil from the tankers onto the highway and consequently into Sungai Gombak and the Gombak intake that was instrumental in causing the harm. That is, the first defendant is the sole contributor to the contaminants. For the fifth issue, it is stated in paragraph 16, the evidence by the first plaintiff's witnesses should be accepted and the plaintiffs should be awarded the full amount of damages claimed. The court's remedy is the Puncak Niaga Sendirian Berhad, the first plaintiff, is awarded nominal damages amounted 50,000 ringgit, while Syabas, the second plaintiff, is awarded 75,000 ringgit with interest of 5% per annum from the date of filing the writ to the date of full realization. In paragraph 70, with regards to costs, Mr. C. Jui Hong paid for 40,000 ringgit as costs for both the plaintiffs and Mr. Tinagaram Batumalai paid for 10,000 ringgit. The court awarded 25,000 ringgit to be paid for both the plaintiffs, which amount the court feel adequate. Thus, plaintiffs' claims allowed with costs.
The first ratio that derived from the first issue is that testimonies from DW1, Mr. Lee Gi Yong, confirmed that the amount of crude palm oil carried by the first defendant tanker before the collision was 25.5 ton, while the amount of crude palm oil that was salvaged from the collision and returned back to its supplier was 13.5 tons. Thus, 12 tons of crude palm oil had spilled onto the highway from the first defendant tanker and flowed into the drainage system of the highway. Moving on to the second ratio is that the fact that there were road construction or road works being carried out along the highway at the material time should alerted Mr. Muhammad Rosli to be more cautious and careful when approaching the said area. That the first defendant is solely negligent, 100% liable for causing the collision with the second defendant tanker at kilometer 29.2 of Kuala Lumpur-Karak Highway. Next, the ratio that derived from the third issue is that the first defendant counsel, Mr. Vignesh, contended that it is impossible for him to know that there are a water catchment area along the highway and the water catchment area had been gazetted under the law. The answer to Mr. Vignesh's contention is simple. Ignorance of the law is no excuse. Time and there was only out of 3 lanes that were open to traffic. Other than that, the ratio that derived from the fourth issue is that the principle of contributory negligence is not applicable to the first plaintiff, as it was the first defendant negligent conduct in causing the collision and spillage of crude palm oil from tankers onto the highway and consequently into Sungai Gombak, and the Gombak intake that was instrumental in causing the harm. That is, the first defender is the sole contributor to the contamination. Lastly, the ratio that derived from the last issue is that the plaintiff, that is the first defendant, had failed to challenge the evidence given by the plaintiff witnesses with regard to the claim for special damages by the plaintiff. For that reason, the evidence by the plaintiff witnesses should be accepted and the plaintiff should be awarded the full amount of damages claimed. The law with respect to a claim for special damages is clear, that is the person who is claiming for such damages has to strictly prove the damages in court.
In my opinion, From the conclusion of the case, it is reasonable for the driver to be charged on the grounds of negligence. As mentioned in the Holy Quran, Surah Al-A'raf, verse 205, and do not be one of the heedless. That means each of person in this world has their own duty of care, and by the time the driver breach the duty of care to be a good driver on the highway, it leads to another consequences. The fact that Puncak Niaga had to shut down its Gombak WTP to prevent the contaminated water from entering the water treatment plant showed that the Gombak WTP was unable to supply and sell the treated water to the consumers, and it is affected for 4 days. And also, the local people need to ration the water, and Shabazz had to supply the water emergency. Hence, by those situations, not just Gombak Deputy got affected, but lots of people. Then, it is reasonable for the defendants to get charged under Section 43 Clause 1 of the Road Transport Act 1987. Then, by those reasons, it is also eligible to give nominal damages of RM50,000 to Puncak Niaga and RM75,000 to Shabazz.